You're thinking about getting married, but you know that more than half of all marriages end in divorce, and you want to focus on beating those odds and not what happens to your assets, debts, or property in case you file for divorce and you need legal help. Hello, my name is attorney Danielle Pinkston. I'm owner and founder of Pinkston Law Group, and welcome to What You Should Know Wednesday. Our topic today is premarital agreements, pursuant to 750 ILCS/10. Today, I'll discuss the basics of premarital agreements in Illinois. And what you should first know is a premarital agreement means an agreement between prospective spouses made in contemplation of marriage and to be effective upon said marriage. A premarital agreement typically points out how the couple will handle assets, debts, and other financial issues during their marriage and if they decide to split up. Formalities. If you want to execute a premarital agreement, you should know that it must be in writing and signed by both parties. It is enforceable without consideration. What this means is you or your spouse do not have to exchange property or monetary value for it to be effective. As long as it's in writing, signed by both parties, it is typically enforceable. So now you're wondering, what types of issues can a prenuptial or premarital agreement cover? Well, parties to a premarital agreement may contract with respect to, number one, the rights and obligation of each of the parties and any of the property of either or both of them whenever and wherever acquired or located. Number two, the right to buy, sell, use, transfer, exchange, abandon, lease, consume, expend, assign, create a security interest in, mortgage, encumber, dispose of, or otherwise manage and control property. Number three, the disposition of property upon separation, marital dissolution, death, or other occurrence or non-occurrence of any event. Number four, the modification or elimination of spousal support. Number five, the making of a will, trust, or other arrangement to carry out the provision of the agreement. Number six, the ownership rights in and disposition of the death benefits from a life insurance policy. 7, the choice of law governing the construction of the agreement. And number 8, any other matter, including their personal rights and obligations that are not in violation of public policy or statute imposing a criminal penalty. So, now you're wondering, who should get a premarital agreement? Do I qualify for one? Do I make enough money for one? Is it necessary for me to execute a premarital agreement? Well, the answer is not so simple, but anyone who wants to worry about having a happy and healthy marriage, anyone who wants to avoid disputes over property, debts, and assets, anyone who wants to remove the doubt of what will happen to their property if they divorce, anyone who wants to help protect their future inheritance, if you want to protect a business or a retirement account or a 401k or a pension or things of that sort that you own to and by yourself, or if you want you and your spouse to divide your debts and assets and property and not leave it to the court or a judge, then you should draft a premarital agreement. So now you're wondering, we have an agreement. What if I need to amend or revoke said premarital agreement? Well, in Illinois, after marriage, a premarital agreement may be amended or revoked only by written agreement signed by the parties. I'll repeat, After marriage, a premarital agreement may be amended or revoked only by written agreement signed by the parties. The amended agreement or revocation is enforceable without consideration. Again, this means that if you're trying to amend or revoke, you do not have to exchange or give the other person something of monetary value or property. As long as it's in writing, signed by the parties, it can be amended or revoked. Now you're wondering, we have a divorce or a separation before us right now. How can the courts enforce the premarital agreement? Well, a premarital agreement is not enforceable if the party against whom the enforcement is sought proves that, number one, the marriage was void. Number two, that the party did not execute the agreement voluntarily, or the agreement was unconscionable when it was executed, and before execution of the agreement that the party or the terms of the agreement were severely or unfair or unjust towards one of the parties. One of the spouses failed to disclose his or her true assets and debts before signing the agreement. That the spouse who did not receive the other spouse's honest financial information did not waive the right to receive it. That the spouse who did not receive the other's financial information could not have known the information any other way. And number 7, if a provision of a premarital agreement modifies or eliminates spousal support, and that modification or elimination causes one party to the agreement undue hardship in light of the circumstances not reasonably foreseeable at the time of the execution of the agreement, a court notwithstanding the terms of the agreement may require the other party to provide financial support to the extent necessary to avoid such financial hardship. That's all the time I have for today. Before I leave you, I want you to know once again that What You Should Know Wednesday is never intended to take the place of a one-on-one consultation with an attorney. If you still have some questions that are unanswered or some concerns, then I would advise you to contact me at my office at 773-770-4771. Again, 773-770-4771. You can also schedule your own consultation online at pinklaw.acuityscheduling.com. Again, that's pinklaw.acuityscheduling.com. Thank you for tuning in, and I'll see you next week for What You Should Know Wednesday.